Welcome back. Late Tuesday afternoon, the decision came down. Dane County DA IsmaelOzannes said Officer Matt Kenny will not face criminal charges in the shooting death of Tony Robinson.
Joining us now to talk more about it is Tim Verhoff. He worked as an assistant DA for more than a decade. Thanks for being with us this morning.
Good morning.
So we were just talking before we started about kind of as you watched your former colleague lay out this case over 26 minutes yesterday. What was your reaction? What were you thinking?
Well, I thought he did a nice job in explaining his rationale of why he wasn't charging this case. And there were some key items that he mentioned as he was going through his presentation that I focused on. The first was the information about Tony Robinson's bizarre behavior that appeared to be related to drug use and the fact that there had been some violent acts. And the fact that that information was conveyed to Officer Kenny ahead of time. And I think that was important because legally there is a concept of if you have information that's specific about someone's violence,
right,
that is relevant in court. The fact that someone might be generally violent or not violent wouldn't matter unless you know of that. In this case, IsmaelOzannes said, look, that information was conveyed by the mobile data terminal. So Officer Kenny knew that information. I thought it was significant that the physical evidence that was discovered on the scene matched what Officer Kenny said in his report. Specifically that Officer Kenny said when he went in, he was struck and it was hitting against a wall. And there was apparently a mark on the wall or some damage to the wall consistent with that. So that bolsters what Officer Kenny said happened. And then Officer Kenny saying that as he was falling or after he'd been struck, that he thought that he was fearful he would lose consciousness or that his gun would be taken and used against him. Those were all significant factors. I think that's what the decision boiled down to, and the concept of if this case was charged, what a jury would have to consider is this notion of everybody's entitled to raise, if it's available, self-defense.
Right.
When deadly force is used, there's a different rubric that it goes through. Essentially, it's a two-part test. The first is subjectively, what did this person believe? Do they truly believe that they were in danger? And you know, Officer Kenny basically said, I thought he had attacked me, had been violent before, and I was fearful of losing my gun. And then the second prong is that objective under the circumstances? And so in reaching that decision and laying that out, and that full analysis wasn't available in terms of, that wasn't walked through, but there was enough information presented, at least as a lawyer looking at it. I totally understood what District Attorney Ozanne said.
Yeah. So the critics have said that, excuse me, this was it was a big case, it was a long case, a lot of information was given in this case. Should he have taken it to the grand jury to decide this, instead of taking it all on himself?
Well, that's a good question. In Wisconsin, we generally don't use grand juries. In Wisconsin, when you are charged with a felony, we use a preliminary hearing process where the district attorney makes a decision to charge or not to charge, and then that information is presented to a judge, and the judge decides whether or not there's probable cause. In the federal system in Wisconsin, we do use grand juries. There is a vehicle to use a grand jury here. They've been used in the past. Grand juries are such that certainly you bring public in to hear the evidence. It's still a secret proceeding at that point, so you don't know what's going on at the time. And you know, you could debate either side of the grand jury. I mean, there's an old joke, you can indict a ham sandwich with the grand jury because the prosecutor presents the evidence that they want to have presented. And so he could present just evidence favorable to indict, or he presents all the evidence and maybe there isn't an indictment.
We have about a half a minute left, but I wanted to get your sense on, did that set the standard, what DA Ozanne did yesterday in terms of going forward in this country, laying out transparently what evidence he had? Is that how you think this is going to go now all over the rest of the country?
Well, I'd like to see that. I think it's helpful for the public. I think that optics are important. You have, in this case, what was nice was the state investigated rather than the Madison Police Department. That helps build transparency through it. The grand jury could build some transparency because you bring in people. But in this case, at the very least, the district attorney went through and explained not only the facts, but his rationale. And now people will review it.
All right, Tim Verhoff, thanks so much for joining us this morning.
Thank you both.
We'll be right back.